Your debit card gets declined at the grocery store. You try again. Same result. You pull out your phone, open your banking app, and then the account is gone. Not frozen. Not locked. Gone. Customer. Service puts you on hold for 20 minutes and then tells you your account has been closed. No explanation. No prior notice. No warning of any kind. And here's the part that twists. The knife, your direct deposit hit that. Account 2 days ago. Your rent is due in 4 days. And that money is now sitting somewhere you can't touch. This isn't a hypothetical. This happens to real Americans, more than most people realize. And the question that every single person in that situation asks is the same one. Can they actually do that? The answer is going to surprise you, because it's not just yes, it's yes. And the reasons why might not be what you think. And the situations where they can't do it are ones most people never know to look for. Before we get into all of it, quick but important note. I'm not a lawyer or legal advisor. This is educational content only. Laws and banking regulations vary depending on your state and your specific situation, so if you're dealing with something like this right now, please talk to a qualified legal or financial professional. What I'm going to give you here is the full picture, the framework. You need to actually understand what's happening and what your options are. So let's start with the uncomfortable foundation. Your bank account is not yours in the way you think it is. When you deposit money at a bank, you don't own a vault somewhere with your name on it. What you actually own is a legal claim against the bank, a debt they owe you. The account itself, the relationship itself, is governed by a contract. That contract is called a deposit agreement. And almost every deposit agreement in the United States, every major bank, every credit union, most community banks, contains a clause that says the bank can close your account at any time for any reason, with or without advance notice. You agreed to that. You probably don't remember agreeing to it because it was buried in a 40-page document you scrolled past when you opened the account. But legally, your signature on that application was consent to everything in that agreement, including that clause. So as a pure matter of contract law, yes. Your bank can close your account without warning. Most of the time, for most accounts, that's the legal reality. But here's where it gets genuinely interesting. Because while the bank has broad contractual power, there are layers underneath that power that can work in your favor. And most people never know they exist. Let's talk about why banks actually close accounts. Because understanding the real reasons is the first step to understanding your options. The most common reason is something called suspected unusual activity. Banks are not just financial institutions. They're also legally mandated surveillance systems. Under federal law, specifically the Bank Secrecy Act and related anti-money laundering regulations, banks are required to monitor customer transactions, detect suspicious patterns, and report them to the government through what are called suspicious activity reports. If your account triggers their automated monitoring system, even if you did absolutely nothing wrong, the bank may decide the risk isn't worth it and close the account quietly. And here's the part that genuinely unsettles people when they find out. The bank is legally prohibited from telling you that they filed a suspicious activity report. It's called a tipping off prohibition. They can't tell you why they really closed your account if the reason involves a SAR. So you're left with a vague explanation, or no explanation at all, and a closed account. This means you could be a completely law-abiding person who happened to receive a large payment from someone the bank's system flagged, or made a series of transactions that matched a pattern their algorithm doesn't like. And you'd never know that was the reason. The bank can't tell you. The law says so. Now, does that mean you're helpless? Not entirely. There's a practice that's become increasingly controversial over the last several years called debanking. And it's worth knowing about because it's reshaping the conversation around your banking rights in a significant way. Debanking is when a financial institution terminates a customer relationship not because of specific illegal activity, but because of a category of business or a type of customer profile the bank no longer wants to service. This has affected cryptocurrency businesses, certain legal firearms-related businesses, political organizations, cannabis businesses in legal states, and others. Banks will often cite risk management as the reason without getting specific. The debate around debanking has become intense in recent years, and it's led to real legislative and regulatory attention. Several states have now passed laws limiting a bank's ability to discriminate against customers based on the legal industry they operate in or their political associations. Texas passed a law specifically prohibiting state-chartered banks from discriminating against firearms businesses. Other states have similar legislation. This is an area of law that's actively evolving, and where you live matters enormously. But let's bring this back to something more personal. Because most people facing account closures aren't running a business. They're just people trying to manage their money. Here's something that doesn't get talked about enough. There are certain categories of account closures that may actually be illegal, regardless of what your deposit agreement says. If your bank closes your account or threatens to close it because of your race, your national origin, your religion, your sex, or another protected characteristic, that is a violation of the Equal Credit Opportunity Act and the Fair Housing Act. Banks cannot discriminate in the provision of financial services based on those characteristics, period. And if you have evidence suggesting that discriminatory targeting played a role in why your account was closed, that's not a contract dispute. That's a federal civil rights matter. This happens. It's documented. Communities of color, immigrant communities, and religious minorities have disproportionately faced account closures and banking access issues that civil rights advocates have connected to discriminatory patterns. Knowing that this protection exists and that it overrides the deposit agreement is something every American should understand. So what do you actually do if your account gets closed? Let's be practical, because this is where the real value is. First thing, request your money back immediately. When a bank closes your account, they are legally obligated to return your funds. They typically do this by mailing a check to your address on file. That process can take anywhere from a few days to a couple of weeks, depending on the bank and your account status. If there's any dispute about the balance or if the bank is withholding funds they claim you owe them for overdraft fees, loans, or other balances, the bank can typically offset those amounts before returning what's left. Get clarity on that number in writing as fast as possible. Second, your ChexSystems record. This is the piece of the puzzle that has serious long-term consequences and that almost nobody understands until it's too late. ChexSystems is a consumer reporting agency, similar in concept to a credit bureau, but specifically for banking history. When a bank closes your account, especially for reasons involving suspected fraud, unpaid fees, or unusual activity, they often report it to ChexSystems, and that report stays on your record for up to 5 years. Why does that matter? Because most banks check ChexSystems before opening a new account. A negative ChexSystems record can make it extremely difficult to open a checking or savings account anywhere for years after the initial closure. You could find yourself functionally locked out of mainstream banking, unable to cash checks easily, unable to set up direct deposit, unable to access basic financial services, all because of a ChexSystems report that may not even accurately reflect what actually happened. So knowing this right now, before anything goes wrong, puts you in a fundamentally different position than almost everyone around you. Check your deposit agreements. Know what bank you're with and which federal regulator oversees it. Your money is yours, but your access to it lives inside a system with rules you probably never read. Now you know enough to read between the lines. And the next time your card gets declined, you'll know exactly what questions to ask.